Welcome to Live at Lunch. Today's topic is when to at least consider starting the employment-based green card process. My name is Emily Sumner with Sumner Immigration Law, located here in Richmond, Virginia, and serving clients all throughout the United States and from around the world with employment-based and family-based matters. And today we're talking about when should you start the employment-based green card process. The answer to that is possibly now, meaning start sooner rather than later. And also, the second part of that answer is it depends. There are a lot of different considerations that go into the decision about when is the best time, or a good time at least, to start the employment-based green card process. So here are some things that you should consider. Number one, what is the employee's current immigration status? If the employee's current immigration status is an immigration status that is dual intent, meaning something like the H-1B or the L, then that visa classification, the H or the L, are clearly dual intent. They allow a person to hold that non-immigrant visa status, the H-1B or the L status, and to start the green card process at the same time. So they, without a question, can continue to work in the H and L status. They can continue to travel using the relevant visas, and they can continue to extend their status as needed or obtain a new visa as needed. That is not true for certain other visa classifications. For example, the TN visa classification, the H-1B one, the E3, any number of other E2, any number of other visa classifications are not necessarily dual intent. That does not mean that you cannot start the green card process while you are in one of those, or your employee is in one of those visa classifications. It does mean that you have to carefully and strategically plan out the process to make sure that there's not going to be an interruption in the foreign national's work authorization, their ability to travel, etc. So that's one consideration, is what is their current immigration status and is it dual intent or not? Again, just because it's not dual intent does not mean that you cannot start the green card process. It does mean that you should be strategic, have a conversation with your immigration attorney about the best plan as to when to start that process and what the pros and cons are starting that process, and have a plan, know what to expect. Another consideration for the green card process that relates to what is the foreign national's current immigration status is how long are they able to hold that immigration status. So for example, if we're talking about someone who is, let's say, working on OPT right now, and you registered them in the H-1B lottery, but they weren't selected in the lottery, how long do they have left in that status, and what is their plan, if any, to extend? So if they're working on OPT right now, are they eligible for STEM OPT to continue? And if so, how is the green card process, starting the green card process now, if you decide to do that, going to impact their ability, like I said a few minutes ago, to continue working and traveling? So that is a consideration, something to take into consideration. Another key consideration, of course, depending on the foreign national's current immigration status, is, like I said, how much longer can they stay in that status? So certain statuses or stati have limitations as to how long a person can remain in that particular status. For example, if your employee is present in the US on L1A status, that in the L1A classification, that can be extended for 7 years total. L1B can be extended for 5 years total. H1B can be extended for 6 years total. And remember that the time spent in H counts against the time limit for the L1 and vice versa. So if you have someone perhaps who has been registered in the H1B lottery, they're about to start H1B status, but they've previously held L status, keep in mind that that status counts against the 6-year limit of H1B. The reason I'm saying that, in particular with this conversation about when to start the green card process, is if you have someone who is on the L, for example, and they have that they have the 7 years of L, they need to make sure to get through the green card process, or at least be at a point where they have the employment authorization document before the end of that 7 years. Because with the L and with other certain visa classifications, once you hit that timeline of the 7 years, you cannot extend beyond that 7-year period if it's an L1A, or 5 years if it's an L1B. with the H-1B visa classification and certain other classifications, but with the H-1B in particular, what I'm talking about right now applies to the H-1B. With the H-1B, it is possible to extend beyond the 6-year limit if the foreign national is at a certain point in the employment-based green card process. Namely, that is if the person has an approved I-140 petition. So regardless of when the person filed or when the company filed the labor certification or started the process, if they have an approved I-140 petition, they can extend beyond the 6th year of H-1B status. Again, regardless of when the I-140 was approved, when labor cert was filed, all of that. And it's important to keep in mind as well that it is possible to use, in certain instances, an I-140 petition that was approved for a previous employer. So let's say that they have an I-140 petition approved for employer A. They can use that I-140 petition to extend their H-1B status beyond the 6th year for employer B, for you, this current employer, for example. The other question, the other way, rather, to extend the H-1B, 6th year of the H-1B status is if a person has the labor certification that was filed at least 365 days before the end of the 6th year. So I'll say that again. If the labor certification was filed at least 365 days before the end of the 6th year, they can apply for an H-1B extension, or the company can submit an H-1B extension request in 1-year increments beyond the 6th year. And they can do that indefinitely as long as they meet the qualifications for that. With the I-140 approval, if they have an approved I-140, the person can request, or the company rather, can request a 3-year extension beyond the end of the 6th year. So extensions of 3 in increments of 3 years, and definitely as long as they are qualified for that. Once the priority date is current, they don't meet that requirement. So keep that in mind, that there are certain additional requirements that you have to meet, but it is possible to extend beyond the 6th year. That, for individuals who hold H-1, really for any immigration status, if you have an employee that you want to hold on to long term, you want them to be able to work for you long term, perhaps you're using this as a retention tool, saying, hey, we are really invested in you, we're going to start the green card process. It is important, really important, that you look at what their current immigration status is, what the long-term immigration status plan is overall, and make sure that you start the green card process in time so that you minimize the chance that they have a period where they're not authorized to work or they're not authorized to stay in the United States. So again, number one consideration, or a consideration at least, is what is their current immigration status? What is the long-term plan to ensure that they can remain in the United States and can remain working dependent on that particular immigration status? Another consideration is the company's immigration policy. So whether it is a formal written immigration policy or an informal immigration policy, a lot of times a company that sponsors foreign nationals on a regular basis will have an immigration policy. Like I said, it could just be in the head of the HR person, or it could be something that's more formal and written down. But a lot of times there is a policy, for example, that will say, yes, we will sponsor a foreign national for permanent residence once they have been with us for X number of years. Another thing to consider with the immigration policy, first question is, do you have one? Is it formalized? What are the terms of the immigration policy? Is there a certain amount of time that the company requires that you wait to start the green card process? Sometimes companies will say, we will start the green card process for individuals in certain positions. So for example, universities sometimes will sponsor faculty, but they won't sponsor staff. And that can be true in any number of different industries. So is it a position that you're willing to sponsor? Looking at the immigration policy, who is going to pay? Do you have it in the budget? So with the perm labor certification process for the very first stage, the perm labor certification process, the employer has to pay. By regulation, they have to pay the legal fees and advertising fees. As of right now, there are no Department of Labor filing fees, so that's not a question, but they have to pay those fees by regulation. So is that in the budget? Are you as a company ready and willing to invest in that process, both in terms of financially and also the time commitment to go through the process? We as immigration attorneys, at least in our practice, we try to make the process as easy, as seamless, as stress-less as possible, but there are things that we need the company to do, and it is going to take time. So think about those things when you're thinking about your immigration policy. Do you have one at all? What does the policy say about this particular person that you're considering starting the green card process for? How does it apply to them? Do you need to wait a certain amount of time? Who will pay what fees? Have you built that into your budget for this particular person? And are you willing to make exceptions? Sometimes there is an immigration policy in place, but the company is willing to make an exception for whatever reason because of this particular foreign national. Another consideration is, has the process already begun? A number of times I will talk to our corporate clients and they'll want to hire a person, for example, and they'll say, yeah, we need to file, let's say, an H-1B transfer for this person, or whatever it is, E-2, whatever it is that we're doing. And they previously started the green card process. So if that's the case, that could be a really good thing. But it's important to get really clear about where that person was in the green card process or is in the green card process. What type of green card process was it? If it was employment-based, was it an EB-1C process that is specific to that particular company and can't really be salvaged or transferred? That's true of perms too. Perms are employer specific. However, there may be some elements that you can save or salvage from that process. So for example, if let's say that you are filing an H-1B transfer for John Smith, who's coming from a previous company, his previous company started the green card process and they have an approved labor certification. He has an approved I-140 petition. It has been approved for 180 days or longer. When he transfers to your particular company, but let's say he hasn't filed the I-485 yet because the priority date is not current yet. So a green card is not available yet. So he hasn't filed that, but he does have the I-140 approval. If that's the case, then yes, you do have to start the process again with your company. Either after you file the H-1B transfer, you can do it at any time. You could do it at the same time, you could do it before. Anyway, you do have to start the green card process for John with your company. However, he should be able to retain the priority date from the previous filing. In addition, he should be able to use that I-140 petition to extend his H-1B status beyond the 6th year if he needs to. So there are advantages, even though you have to start the process over again with your company, there are advantages to having the I-140 petition approved. In addition, depending on where the person is in the process, I have also had companies who want to hire a person and they have gone through whatever the process is, the labor certification process, for example, and they have the I-140 petition approved and they have filed the I-485. There's something called portability, green card portability, meaning if you meet certain requirements, then you can port the green card application to a different company without having to start the process over again. High level, those requirements are that the I-140 petition be approved or approvable. I like to see that it was approved, but it technically just has to be approvable. The position has to be the same or similar position as what they're moving from. So if the person that you're wanting to transfer is moving from company A in a position as, for example, a rocket scientist, for example, then they need to have the same or similar position. They can't come and work as an accountant at company B that's not the same or similar position. And then separately, the I-485 has to have been pending for at least 180 days or more. So again, there are certain requirements that they have to meet, but they may be able to transfer that entire process and you don't have to start that process over again with your company when the person transfers to your particular company. So that's another thing to consider. Have they already started the process? What process was it? Where are they in the process? And what parts of that, if any, can you salvage and apply to their new employment situation? When considering when to start the employment-based green card process, another consideration is the timelines. Understanding the timelines that are involved in the green card process. It of course depends on which employment-based green card process we're talking about in terms of timelines. And we have, if you're not sure exactly what all the options are, in general, a person who is working for a private company and being sponsored by that company for the employment-based permanent residence process, in general, likely will go through the PERM process, but their PERM labor certification process. But that is not the only option that's out there. If you want additional information, we have a series of videos in our Sumner School Business Immigration Basics series on YouTube. I'll put the link to that in the comments, but we are just starting now the employment-based green card processes. We talked a lot about different non-immigrant visa classifications, but we're starting to talk about the permanent residence options as well now. So understand the timelines, regardless of the process that you're going through, understand the timelines, have realistic expectations of the timelines. When I say timelines, I'm talking about both the preparation timelines, how long is it going to take to prepare the case? So if we're talking about an EB-1C, for example, which is for multinational executives and managers, then there is no labor certification process, which is great. But it is going to take some time, several weeks to months to prepare all of the documentation that's required to put together a solid filing. Likewise, if you're going through the perm labor certification process, the preparation process from the time you start the process to the time you're able to just file the labor certification application is probably going to take a year. That's an estimate. But it's probably going to take a year just because of all the steps you have to go through. There's an intermediary filing that you have to do, the prevailing wage determination. So have a clear understanding of the and realistic timeline, understanding of the timelines that are required for the particular process that you're going through. So we're talking about preparation time, we're talking about government processing time once you file, and we're talking about what is the wait for the green card going to be. There is a limited number of employment-based green cards available every year. And there's so many people, it's 140,000 limit every year, give or take. And there are so many people who want a green card that there's a virtual line of people waiting. Your place in line depends on a number of things, including your country of birth, your priority date, which is the date that the labor certification or the I-140, if no labor certification is required, is filed, and the employment-based classification. That's a whole separate video. We actually have a video on the visa bulletin and priority dates in Sumner School Business Immigration Basics. So check that out if you're interested. But just know that a green card may not be immediately available, and that could impact your planning for the green card. And then finally, think about other options that you have available or that your employee has available. So again, in talking to corporate clients, it's very common, not uncommon, for HR to say, for example, hey, we have this employee and we need to start the H-1B extension. Also, they're going through a marriage-based green card process. How does that impact our processes? And the answer, of course, depends on the specifics of that particular person in their case, but it may be in some instances that you as the employer don't need to sponsor the person for their employment-based green card. Or it may be that you start the process and then later on down the line, they have a family-based process that they're able to take advantage of. That doesn't always happen, of course, but it's something to consider. So these are some of the key considerations for this very short answer, when should I start the employment, or short question, when should I start the employment-based green card process? Like I said, there are multiple considerations from different parties. You're thinking about considerations from the employer, from the employee, how long is it going to take working with the immigration attorney, waiting for the government processing times, waiting for a green card to become available, financial considerations, family timelines. If an employee has children that are aging out of the process, that could affect your green card strategy as well. So many considerations, not really a clear answer, but those are some key considerations or key factors to take into consideration when you're thinking about when to start the process. In general, and none of this is legal advice, it's for information and educational purposes only, but in general, I would start having the conversation probably sooner than you think that you need to. If you know that you want to stay in the United States, if you're the employee, or if you know you want to really make sure you do everything you can to retain this employee, if you're the employer, start that conversation and at least the planning sooner rather than later. And that will hopefully set you up on the path for long-term success. I hope that you will join us next time at our Lunch at Live at Lunch. I can never get that right. Live at Lunch. That will be next Tuesday at noon. Make sure that you subscribe to this channel wherever you are following us, whether that is Facebook, YouTube, or LinkedIn, for more content. And I look forward to seeing you next time. Take care.